All right, good morning, everybody, and thanks for those that have logged on, and thanks for those that are going to watch this over and over. Jackie and Ted are going to become movie stars in our little world here for us. Jackie doesn't need any introduction. I know most of you know her very well. I've known Jackie for I don't know how long, been a couple minutes. And she's been a super supporter of not only me, but our brokerage and realtors in general. And we've had great success using her firm over the years. So, Jackie, you don't need any introduction. You have a great firm. But if you'd be so kind and introduce my new friend, Ted, Ted and I don't know each other, but we're going to become friends.
Thank you all. Good morning. It's nice to see everyone, all of our friends in real estate. I'm here together with attorney Ted Prizio. He's a New Hampshire and Massachusetts real estate title attorney. I also like to think of him as almost like a forensic scientist for real estate because he is in the weeds of the research together with a few other internal in-house title attorneys that mine through all of the public records and sometimes private records, because sometimes we're looking at family trusts and other documents that relate to the ability to sell. And so he's joined us today because the topic that we'll be speaking on relates so closely to title.
Awesome. Ted, would you like to say anything? Where are you from? All those kinds of things.
I'm from Wyndham, New Hampshire, and I appreciate Jackie's introduction. I'm here because every single time you guys do a PNS, I end up reading it. So I'm happy to talk about what helps us do our jobs.
And can I
Great.
just brag for one quick moment and let you
Please.
know that Ted has a beautiful tie to the Upper Valley, which is that he is a Dartmouth alum.
Awesome. Awesome. Great school. Well, thank you. Thank you both for coming on. So, um, you know, those that are on the call can ask a bunch of questions, as we all know. But what I asked Jackie to come on initially, just to start the conversation, was what are some examples of a proper legal description on a purchase and sales agreement here, at least here in New Hampshire?
Okay, so let's talk about how real estate is identified in the contract. So you're looking at section 2 in the purchase and sale agreement where the property is identified. So most routinely, a US postal mailing address is used to advertise the property in marketing materials, and it's usually typed into that section 2 of the contract. That's just a clue of what is being sold because, as we know, addresses change and sometimes don't reflect all that's being conveyed. So that's clue number 1. Clue number 2 is the book and page reference also in section 2, which points to a legal description. So when you add a book and page in that section 2, it's presumed that everything in that book and page that comprises the legal description is swept into the conveyance. So it's important then to look at the legal description in that book and page. What we find, however, is sometimes there are additional parcels of real estate that are being conveyed, or sometimes a seller wants to accept and reserve portions of that book and page that should not be conveyed. And there's no intention to convey. I'm kind of speaking very high level here, and then we'll get granular. The other way to describe real estate in section 2 is sometimes a book and page is not yet available because it's a new lot coming out of a subdivision. And in that case, we're going to reference the plan, hopefully a recorded plan. That's the only way we can officially convey, is if a plan has been recorded. And then we're going to reference that plan, the recording date, the name of the plan, and the lot number that's being conveyed. Now, that all sounds very easy, but I think Ted is going to jump in and let you know when either that's not enough to tell our title examiners where to start or what to examine, or when there's a little bit of confusion, or sometimes when the game has changed. Like, for example, he might get into this example. We had a situation about a month ago where a realtor used a tax card which had a book and page on it, which was a very fair and reasonable approach to identifying the real estate. But the book and page reference on the tax card was wrong. So we examined the wrong parcel and we almost conveyed the wrong property. So I'll let Ted jump in and chat about other aspects that trip up title and what we can do together to point title in the right direction and to give certainty to the parties so the buyer knows what they're buying and the seller knows what they're selling.
So as Jackie said, you're usually starting with an address, and the address can be very helpful in looking up the town tax card. The town tax card, as Jackie said, is not always right. So that's a big caveat, that if you're seeing something in your deal that isn't quite matching up, that the acreages aren't what you were expecting, or there's some other factor that doesn't look right to you, then it's good to ask more questions. The town tax records are extremely useful to us in our jobs, but that's not really what dictates the title search. The title search is going to be based, as Jackie said, on deeds in the registry of deeds, or sometimes if someone, this is another example where there wouldn't be a book and page, is if someone inherited the property through a probate action and nobody ever did a deed related to that transaction. So you might have a deed from 1945 and someone inherited it in 1989. And so the quote last deed is 1945, but it's not to the person that's currently selling. So just keep in mind, I guess, that we're always looking for the last deed, because that's the starting point in our quote chain of title as we look further back. But it's not always the end all be all of what determines who owns the property. Again, anytime you have someone who is either selling out of an estate or has taken the property from an estate, there's maybe additional questions to be asked.
We're going to open this up, of course, to questions. It should be a fluid dialogue, but 2 points that Ted made, I'd like to flesh out a little bit more. He touched upon acreage. I want to just comment that it is very common for acreage in a tax card to be estimated and to be different than what is in a legal description in a deed, which can also be very different from information gleaned from a survey. So these legal descriptions that we have in deeds from long ago may not be wrong. They may be correct, but they are not precise, because we didn't have modern survey instruments decades and decades ago, when our rural parcels of New Hampshire were carved out and natural monuments like rocks and trees and boots on the ground were used to take measurements and to create milestones for boundary lines of properties. Now today we have these modern survey instruments, and properties are starting to, in our rural areas, be sort of sliced up, and precision of boundary lines is becoming more important to certain types of buyers. They get very tripped up when they see acreage on a tax card that is different from the acreage that is in their deed. In fact, I know that we all handled together a matter where acreage in the MLS listing was pulled directly from a tax card. That was a very reasonable approach. It was acreage taken directly from a tax card, put directly into MLS. The buyer relied on that information, but in the legal description of the deed, the acreage was different. So the only way to determine what acreage is accurate would have been to obtain an instrument survey. Now, to some buyers of real estate, it doesn't matter if they're going to own 13.5 acres or 14 acres. It doesn't matter where the 14th acre ends and the neighbor's property begins, because it's all woodlands way in the back of their property that doesn't impact their use and enjoyment. But then you have discerning buyers that are either discerning naturally, or maybe they want to, it's a smaller parcel and they want to put a pool in the backyard and a fence along their boundary line, or they want to plant some fruit trees and they just really want to know where their boundary lines are. So if you see these discrepancies, you just really want to start having these conversations with your clients. Make sure they understand that they cannot rely upon acreage cited in a tax card or acreage in a deed that says something like 3 acres more or less. You've all seen that language? So that was one important point that I wanted to make from Ted's comments. Does anyone have questions so far?
Yeah, so it's interesting. I've had it happen to me years ago. I did sell someone a parcel of land, and then they a few years later decided they wanted to subdivide when the town tax card said they had enough to subdivide, but then the deed was different. So when I'm not an abstractor. That's not my jam. I enjoy researching the county registries and deeds. I enjoy reading deeds and going out and walking stone walls and all that kind of stuff. However, when a real estate agent takes a listing, which one, the town tax card or the deed, should we be referencing that's weighted heavier than one or the other?
Ted, do you want to take that one?
No. So I think that it's the beginning of a quick inquiry, not as Jackie said, the real answer is somebody doing a survey. If the deed description goes back to 1845, then I would not be counting very much on the acreage in the deed. If the deed came from a legal description, and I'm trying to think of an example that's more recent or more defined, or sometimes our lot isn't on a plan, but the surrounding lots are on a plan. Sometimes we can come up with an answer to, hey, wait a minute, now we know why this deed does or doesn't have accurate acreage. But I want to point out that the town is always taking their acreage from other sources. So I would not, I think Jackie's 100% right that it is a reasonable position to take, that you're going to take information that the town has and share that information as if it's true. But if you see discrepancies, I think it's very hard to say that you should always rely on the deed or always rely on the tax card. That might be an opportunity for you to have a conversation with the seller. Do they know anything about what do they know about the history of the property, and do they know anything about it? There are times that people have had surveys done that have not been recorded in the registry of deeds. And all of a sudden we have someone pop up and say, oh, I can tell you it's 13.8 because my uncle had a survey done before he sold the property to me, but we never recorded it for whatever reason. But Jackie, I don't necessarily have a position on, do you always go with the deed or the tax card?
Well, I think so. Ben, when you asked which one is weighted more, it's interesting. What I will say is the registry of deeds always wins. And the registry of deeds is always current, more current than a tax card. Because in New Hampshire, we have this, it's called a race notice jurisdiction. Whoever gets to the registry to record something first wins. The tax records lag behind. They're not updated, they're not refreshed, there's just not the technology to synchronize the registry of deeds with the tax office. And I don't think that there's a staffing to handle the updates. That's why sometimes ownership on a tax card is also not accurate, or it's not complete, because not every seller or the current seller owner is listed on the tax card. There may have been a recent change. In fact, I had an abstractor look at a deed yesterday, and that day at 10:45, like 2 hours before I asked her to look at it, there was a change. It was just a change from individuals to their trusts, but it was still a change. So minute to minute, there's a change. The tax card is not going to be updated maybe for many months, maybe not even until next tax year. We don't know. So I would say the Registry of Deeds, for that just for that reason, I'm gonna say it trumps because it's more current. And it's tied to the whole family tree of the property, right? Whereas tax cards, when you look at one, it's not tied to the whole history of ownership. So you can think of a deed like a leaf on a family tree. It's connected to a whole tree. That is the way a deed is recorded at the registry. We can tie back to the whole history, and everything in one deed is related to all of the deeds attached to it or behind it on the record.
Yeah, you know, I know there's some states out there that you do have a survey for every time real estate's transacted. I would love that to happen here in New Hampshire, and I would love for us to have a title search done right up front before the deal gets too far along, and then have another one towards the end. I know some states do that. That would be great too, but I don't have that power to wave that wand to make those things happen. But I think it's interesting. I mean, we could go on all day about this topic, just in that, um, it's a lot of real estate agents, and I'm not making fun of anybody or picking on anybody, but a lot of them, right? They just look at the town tax card and, oh, that's the acreage. Or they just look at the deed and, oh, that's the acreage, and didn't look at both to see if there is any major differences. And if there is, uh-oh, now what do we do, right? I'm going to ask one other question, and then I'll just let everybody else jump in, because I could go on about that. This could be a whole 3-hour class, to be honest with you, if not longer. Um, so when a real estate agent takes a listing, the other topic I've always thought about that is concerning or a problem is proper names when we put down who the seller is, rather than just Bob and Sue, because his real official name is Robert and hers is Suzanne, right? Should we be being a little more accurate with proper names when we put down who the sellers and or buyers are?
Okay, I would say yes, make a good effort, but let's think about what is the purpose of a real estate purchase and sale agreement. It is to bind the parties to the deal. It is to satisfy the statute of frauds, which makes a contract valid, binding, and enforceable, meaning it must identify the parties, it must identify the property, it must have a timeline, and it must have a consideration amount, the purchase price. So if you call Bob Smith, of Robert Smith, Bob Smith, you're still identifying him. So I would say you've satisfied the statute of frauds, which makes a contract legal, valid, binding, and enforceable against that party. But it's then time to go and clean up administratively and clerically so that everyone to the transaction has a perfect blueprint of how to prepare all of the closing documents. Because, and we might see that when we look at the record for Bob Smith, we're going to find that it's really Robert J. Smith Jr. And we're going to, especially if a lender is involved, we're going to want to see a cleanup of that purchase and sale agreement so that everybody is on the same page with preparing documents, settlement statements, and deeds. We like to see the clarity. Also, keep in mind, whether you're with a seller or a buyer, these people forget who they are and they forget what they did with their ownership. So husbands and wife convey in and out of trust, they add siblings, they add children, they remove those parties, they make lots of changes. Other times when you might not know what parties to list on a purchase and sale agreement could be in the event of a separation or a divorce. And a spouse that you're meeting with in the house as a listing agent might have been awarded the property through a judicial decree, a divorce, a divorce decree, an order signed by a judge. So the person that you're meeting with to take the listing might be the equitable owner of the property, but there's also a record owner that hasn't yet relinquished their rights as a matter of the record. So even though they might not have a right to weigh in on the terms of the sale, or the conditions of the listing agreement or the deal that you're making with your client, that title holder, that ex-spouse title holder is going to have to join in some capacity to sign the deed. And sometimes also buyers make changes. They decide they want to take title in the name of an LLC or a trust, and it is important to go back and clarify so that you have memorialized the intentions of the parties before you can do that with a PNS amendment that can be sent to the lender and circulated to everyone.
That's great. That's good information. Go ahead, Jackie.
Well, can I jump back on one point you
Yeah,
made,
yeah,
Ben,
yeah,
about
yeah,
an upfront title search and
yeah.
the pros and cons of surveying all property? Massachusetts, let's say the newer states out west are on these grid line formats, and so their properties are surveyed, so that's common. In Massachusetts, we have this thing called land court, where also properties were surveyed and they're transferred by certificates, and they tried it. It didn't really go so well. But so I don't know. I think also in rural New Hampshire, it would be extremely costly to roll this out. However nice it would be to have the certainty, it's a very expensive endeavor. But the upfront title search is interesting. So here's the analogy that I know will hit home with all of you. A seller doing an upfront title search is exactly the same analysis as a seller doing an upfront home inspection. Only sometimes is that a good idea, because as realtors, you have an ethical duty to disclose what you know about a property. And sometimes you want to do that. Sometimes a seller wants to get ahead of their home repairs. They want to know everything. They want to address certain things. And it's the same with title. Sometimes you want to take some curative action. You want to be proactive. And other times, just like with a home inspection, you really do strategically want to shift that burden to a buyer to do their own due diligence, because everyone's sensitivity meter is different. So I'll let you think about that.
Yeah, no, I totally, I understand where you're coming from. I mean, I just look at it as too that I just take my parents as an example. Um, they would have no idea
Mhm.
where their property lines are at all. And they're getting older, which is fine, but I'm one that I always used to go out and walk the lines and flag the pins and all that. Real estate agents don't do that anymore. And I understand why we don't. We're not surveyors, right? And I'm not an abstractor. So if I go to pull somebody's deed, I'm just winging it, to be honest with you. I see their names, then the address. Looks like the property we're supposed to be selling. So you're right. I do agree, Jackie. Having a survey done up front would never happen. It would just cost way too much money, but way too much money. So let me just say, who else has some questions? Because I could go on all day and I don't want to keep these folks too much longer. But Kim, anything? Susan, what do you have?
I do have a question. I actually have a property coming up. I believe it's 21 acres. So let's say that the tax card and the deed do not match. Should I write that somewhere? Should I put that, under agent comments or something in the MLS? Like, how do I cover myself, basically?
The two things that you mentioned are both of the part of the public record. And if you include them in your listing package, you
Mhm.
have affirmatively disclosed. Whether or not you need to take another leap of pointing out the discrepancy is a very good question. But know that you've satisfied the duty by putting that information into the listing packet.
Okay, great. Thank you.
Yeah.
What about relative to that, to Kim's thought there with those two differences? and I know we don't have a lot of time left, but in our due diligence section of the purchase and sales agreement, right? This is where the buyer has however many days we put in there for them to do the due diligence. What have you seen in your careers for what buyers may do if they've ever reached out to you to do some due diligence for them? Because we can sit there and hand them the deed, and yeah, it might say that there are some encumbrances on the property, but I don't know what those encumbrances are because I don't know how to search for deeds to find out what any of that other information is.
So we do offer this title due diligence service. It's an expanded service beyond a straight title company. Is the title clear search? Is it marketable? Is insurable? That's the easy part of title. Are there outstanding liens and encumbrances? That's paragraph 9 in the purchase and sale agreement. We're talking about, and that's also a very objective standard. It's a prudent buyer standard. Everyone would agree a defect is a defect, but contrast with paragraph 15, it's a very subjective, very discretionary standard. Do I like that there's an easement that says that everyone that lives on the private road can use the path that runs along the side of the master bedroom to access the lake? Am I going to be okay with living with that? Am I going to be okay that the neighbor has a view easement that says I have to cut trees every 5 years, and how much is that going to cost me? I want to have chickens at my house. I don't want the Purdue chicken factory, but I want to have a few eggs on Sunday morning. So I want a few chickens. Are there covenants and restrictions that say I can't have chickens, I can't have horses? These things trip people up. We have people that back away from deals because of these things. We also have people that come to the table more comfortably when we teach them about these things. Like, for example, the gentleman that saw in a deed that he couldn't cut a tree. And we were able to expand the research to show that it was just that you can't clear cut trees. You had to preserve a natural buffer zone between properties for privacy and noise mitigation. So that person gained the comfort from that title due diligence to come to the closing table knowing what his title meant for him. We do need time to do this research, though. It's not a 2 and 3 day affair. I'm going to let Ted jump in from here because he's in
Well,
charge of the title
I,
due diligence.
I think Jackie makes a great point, which is that we then do more research so that we can teach the buyer about the property more than just giving it a check mark, but teach them what's involved. Sometimes, so, typically a search in New Hampshire needs to go back 35 or 50 years. Sometimes we have to go back further than that for some of these things to see what, not as much declarations of restrictions and covenants, but more, like Jackie said, easements and things like that. So if you give us 3 days, we may not be able to tell the buyer anything in those 3 days. If you can give us longer than that, substantially longer than that, then we can give the buyer not only the information, but have the buyer have enough time to ask questions, think about it, and then make a decision on their, releasing their contingency or letting the deadline pass. But I think it's something that our firm really enjoys doing with clients. But I understand the pressure to do shorter timelines is high, but the more time you can get us to do it, the better job we can do for the client.
Susan.
So Ted, what kind of time are you talking about? Because everything's happening at once. You're trying to get the contract signed, you're trying to get your inspections lined up, you're trying to apply for a mortgage in some cases. So what are we talking about a timeline for this particular situation?
I think that a safe timeline for a normal search that isn't 85 acres of complicated stuff. So I'm just talking about residential property. Residential property, I think, Jackie, we are most comfortable if someone gives us a week to 2 weeks. And
they have to let us know on day 0, though. That
is a great point. That if you tell us the day after, and we have we have 8 days to do the research and get the information to the client, then that gives us a few days to do the research and then talk to the client. If we get the if we don't start the title search until the 4th day because nobody comes to us for whatever reason, then it gets a lot tighter. You know, we can turn around a title search in a few days, but as I said, sometimes these searches require more than a typical title search and going back further.
Okay, so we're looking at maybe 10 days?
I would love it if it were 10 to 14 days, but I
Okay.
understand the pressure not to necessarily go out that far. The only other thing I'll say about that is if there are other contingencies that are going out that long for whether it's home inspection contingencies or other particular contingencies, having those line up is great for us because we can talk to the client about they can make a decision about a number of issues at the same time.
Okay,
You know, if someone gives us 3 days and then gives 15 days for some other, you know, contingency, then it's like, well, you know, that just puts us in a real tough spot.
okay.
But I understand that I can't state enough that I know when, you know, people say, well, what would take so long? Well, like I said, if there are easements that go back to 1945, then that research would really take longer than a typical search.
Okay, thank you.
Thank
Yeah,
you.
I've always just had a practice of mine that if I am having home inspections, I've always taken that 15-day home inspection thing and tied it to the due diligence. So all my dates are kind of jiving together. You know, that's kind of how I've done it over the years. But the point that Jackie and Ted are making is, you know, we get a signed P&S and we put down that we're going to do 15 days and we've ordered the home inspection, but on the 7th day, we're like, ah, damn, we got to get that due diligence stuff going. Well, we just ate into our 15 days by 7. So we're behind the 8 ball a little bit. So I think that's a great point. We could go on all day talking about a couple of these topics, and we've only touched the surface, but I want to stay to our time because I appreciate you guys coming on. I would love for you guys to come on as often as you'd be willing to. So I will definitely reach out to you because I we could just take one topic and go on for an hour all the time. I know. Now there's one other thing I want to bring up today before I let you guys go. And Ted, over your right shoulder, am I looking at a historic thing or is that a backdrop that's fake? Because that thing should be in the Smithsonian, my
I
friend.
noticed that too.
That is my Apple IIe from when I was a kid. So I
Wow.
got it set up a little while ago and I've been poking around and I recently said I'm going to beat a game that I couldn't beat when I was a kid. So I do use it sometimes, but yeah.
I think probably
It's
when you
funny.
turn that on, the lights go, you know, something like that, right?
The noises it makes are a lot louder than our computers today. So,
Oh, that's awesome. Jackie, Ted, I can't thank you guys enough for coming on. We'll definitely have you on again. I appreciate it very much. Ted, you're going to say something.
yeah, I just wanted to say that if anybody has any questions, send them to you and that you can forward them on to us. I'm happy to talk to somebody about a specific situation now or in the future. Again,
Awesome.
whether
Yeah,
it's
you guys have
general or
always been,
yeah.
yeah, you guys have always been very, very easy to approach and ask, and you've done favors for us over the years. So it's greatly appreciated. Thank you both again. Thank you for those that logged on today, and go out there and have a beautiful day in the fall here in New Hampshire.
A pleasure. We love real estate just as much as you, so happy to talk anytime.
Thank you
Thank
guys very
you.
much. Have a good day, everybody.
Okay.
Take
Bye.
care.
You too.
Bye-bye.